Crimes Against the Economy, Antitrust. Module 6, Readings 1. Let's start with the Sherman Antitrust Act, passed in 1890. It was written by John Sherman, who was an Ohio senator and brother of General William Tecumseh Sherman, the famous Civil War general. The law was surprisingly brief, making it in many ways vague and ambiguous for future courts to interpret. It had relatively limited penalties built in, which showed some deference to the corporate interests, even if the law was itself a product of a large populist upsurge of protests against corporate concentration. And both the prosecution side from the federal government and the courts themselves would have little or no enforcement against corporate monopolies for the first few decades that the law existed. The DOJ filed just 9 cases in the 5 years following passage, only 16 in the first 12 years, and 22 during the first 15 years of the law's existence. And when the Supreme Court had one of its first major interpretations of the law in 1895, in the case US v. EC Knight, it declared that a sugar refinery monopoly, which at the time controlled almost all sugar refining in the US, while it was a monopoly in manufacture, it wasn't directly involved in commerce, since others were selling the sugar across the country, so it was not covered by the Act. By excluding almost all manufacturing monopolies from the law at that point, it largely made the Sherman Antitrust Act a dead letter for many areas of commerce. In fact, the law was mostly used against labor unions in its early days, imprisoning most famously Eugene Debs, who was the head of the Railway Workers Union at the time and would become a future presidential candidate for the Socialist Party. The case that really brought the Sherman Act into the beginnings of an effective, if limited, instrument was the 1911 Standard Oil case. That began the period where the Sherman Act would actually be used to go after some monopolies across the economic landscape. The court held that combining of the defendant's stock constituted a restraint of trade in an attempt to monopolize the oil industry. What that meant was the company, which was in that case a holding company of many subsidiary companies, had used its power to negotiate rebates, preferences, and other discriminatory practices to favor its combination against other competing oil companies, largely because of its relationship with the railway companies of the time. It used its control of pipelines and predatory pricing to put many competing pipelines out of business. The court case established what became called the rule of reason, to look at all evidence and whether that evidence shows that a particular monopoly inhibits a reasonable degree of free trade. The next update of the Sherman Act was in 1914, what was called the Clayton Act. Congress added this and at the same time enacted the Federal Trade Commission to actually strengthen the antitrust crusade and strengthen the legislation to put more teeth in it. Now, part of this, though, was even less focus on criminal law approaches and more towards administrative regulation, looking at economic sanctions to stop unfair competition. The Clayton Act enumerated 4 practices to be regulated: price discrimination, charging different people different prices, tying one good that you're selling and forcing customers to buy another, exclusive dealing contracts, saying that anybody who took your goods had to take your goods and only your goods, looked at mergers between companies that were previously separate and doing standards for when they could or could not be merged, and looking at the problem of interlocking directorates, where companies would own each other, would own different companies, and trying to get at the idea that financial control, not just a single corporation, could create a problem of anti-competitive antitrust violations. There were later amendments as well. The 1936 Robinson-Patman Act, which buttressed the price discrimination ban. The Keller-Kefauver Act of 1950, which toughened anti-merger rules. The Antitrust Procedures and Penalties Act of 1975, which changed violations of the Sherman Act from misdemeanors to felonies and increased maximum fines. And the Hart-Scott-Rodino Antitrust Amendment Act of 1976 required prior filings with the government before you could do a major merger. That way, the government could head off monopolies at an earlier period. At least this was the theory behind many of these amendments. One of the more recent cases that brought a whole set of new issues to the table as far as antitrust was the Microsoft antitrust case of the late 1990s. The DOJ and 22 states filed suit in 1998 against Microsoft, with a focus on the way Microsoft bundled what was then its dominant Explorer browser with Windows to undercut competing browsers for control of how people would access the internet. This raised novel issues of antitrust in the information age. At that point, Microsoft had 95% of control of all Intel-compatible PCs, and even if you included Apple, at that point it had 80% of all personal computer operating systems. What Microsoft attempted to do was create barriers to entry to challenge that operating system monopoly, from controlling third-party developers of software and using the installation of the internet browser to undercut inner-based challenges that might have undercut its operating system dominance. And it was accused of undercutting overall innovation in the internet world, since other firms feared wasting investments if Microsoft could step in and undercut them. This idea of antitrust being used to protect innovation is increasingly a focus of much antitrust discussion. Microsoft lost at the district level. And while the appellate court accepted many findings of fact from the district court that there were problems of monopoly, it overturned an initial legal remedy which would have broken Microsoft into two separate companies, one for its operating system, one for all of its other software like Microsoft Word and Excel. In 2001, the DOJ and Microsoft agreed to a settlement that the company would open up what was called its Application Program Initiatives, APIs, to make it easier for third-party companies to add software that would be compatible with its Microsoft operating system, and created a panel to oversee compliance. There were a lot of debate on how effective this was, but many people actually said even with this limited restraint on Microsoft's expansion, it opened the world in the 2000s for companies like Google and Facebook and others to enter and arguably now have their own forms of dominance on the internet. Looking to the problem that since this Microsoft case, there have been no other major antitrust cases in the internet world. Many argue, as in your readings, that antitrust is in some ways part of a US aversion to a more general oversight of corporate governance. James Madison, who was very involved in both writing the Constitution and would become our fourth president, proposed having all corporations incorporated at the federal government level. This didn't pass. And in the progressive era, there was a new push for a corporate regulatory model instead of just antitrust, but that was also defeated. So what you had instead is a rise of essentially a crime tort model in which antitrust law creates a freestanding norm of competition between companies rather than a regulatory apparatus to figure out how to make sure firms are operating in a open and decent way in the market. Now, the problem here is instead of having a regulatory system defining what's the proper way for companies to operate, that's what's over actually in Delaware at the state level in Chancery Court, you have just what some see as a pathology of just focusing on bad acts, that there's almost a tripwire, that companies can do anything until they accumulate a certain number of bad acts that bring down the antitrust hammer. The other problem is instead of having specialized regulatory agencies overseeing what happens with corporations, you have generalist federal judges dealing with cases that come before them in this tort model. So you don't have the expertise to really think about what makes a company work, what is the proper way to encourage the best practices, and instead, again, this bad act focus. What it means is most of the enforcement is by competitors suing for losses they, as private companies, perceive losses due to anti-competitive activity, instead of a broader public oversight. The other alternative has been state incorporation laws, which has been a weak alternative. At the time of the Civil War, the history was that most corporate charters limited companies to often a single line of business. But that rapidly changed. After the Civil War, states liberalized statutes because they wanted companies to incorporate in their state. And by giving corporations more and more license to go into any enterprise they might wish, you ended up a race to the bottom in state corporation law. New statutes allowed corporations to own stock in other corporations. They could do charters for any lawful business purpose. They ended requirements that directors actually live in the state where the company was incorporated or even hold meetings in that state. It allowed unlimited capitalization, so companies could get as large as they could raise capital, and it meant shareholders were no longer liable for corporate debts, meaning companies could do any number of bad acts and the company might go bankrupt, but the shareholders were protected beyond whatever their investment was. And it didn't even require public disclosure of annual reports under most of the new state incorporation laws. Initially, New Jersey, by 1891, had created a model holding company act that encouraged trusts across the country to locate in that state. And very quickly, by 1901, 60% of state revenues were coming from these filing fees, and 95% of large corporations then incorporated in NJ. More states would follow suit in their incorporation laws. Delaware, which would pass the most liberalized laws, ended up as the headquarters for most corporations by the modern era. I had mentioned there was a push in the progressive era for federal incorporation, but it didn't work out. Williams Jennings Bryan, as part of the populist movement in 1896, had led the charge for federal licensing of interstate corporations. Teddy Roosevelt argued corporations were, quote, creatures of the state and should be regulated by the state, but no federal incorporation followed. You did have the passage in 1933 and 1934 of the Securities Acts at the federal level, and that did lead to some debate on going farther to federal incorporation laws. But by addressing the specific harm of shareholders being defrauded, it undermined support for more extensive federal incorporation laws. The Robinson-Patman Act of 1936 added some new antitrust rules and stepped up enforcement, but it also added to the argument that current laws could deal with any problems. What you ended up with was corporate law, largely operating in Delaware, ended up completely divorced from antitrust. And The result in the current economy has been rising economic concentration. By 2014, the rate of returns for corporations in the top 10th percentile of corporations was 5 times the profit rate for the average firm. Compare that just as recently as 1990, when the ratio was only 2 to 1. The rate of new business creation has fallen dramatically over recent decades. For all politicians talk about the importance of small business, they're not the ones driving most new business creation. You're having large companies spring forward and often just being bought up by the biggest companies almost as soon as they get any degree of success. Wage inequality between workers in the largest, most profitable firms versus the smaller, less profitable firms has continued to increase. So the employees at Google make far more money than employees at McDonald's, to take the extreme example. The total merger activity in the US has now surpassed $2 trillion annually, breaking records. And the total number of banks that have failed have been 60% since '81. That has meant banks have been bought up by more and more concentrated firms within the banking industry. Another example is Google, which controls 70% of search in the US and 90% in Europe, and, as importantly, controls an even higher percentage of all search advertising revenue. And largely, this has been because of weakened antitrust enforcement in recent decades, not because the laws have been rewritten, but because of how courts have interpreted those laws. Antitrust enforcement probably hit its peak in the mid-20th century, when instead of breaking up a lot of the largest monopolies, it largely increased regulation, saying that, yes, we're going to have large industrial firms, but they'll operate under tight court supervision at times once they get too big. This coincided with an era of public utility regulation, when companies like AT&T and energy firms would exist, dominate their industries, but be tightly regulated by state and federal governments. The 1970s saw conservative scholars and policymakers begin dismantling New Deal approach to antitrust regulation and convincing courts and some policymakers to move in their direction. Merger guidelines were weakened, and under Reagan, most antitrust enforcement halted. In fact, the 1982 merger guidelines focused only on would the merger increase prices for consumers, not worrying if the market itself would become concentrated and competition would largely be sidelined. It encouraged very permissive merger rules. At the same time, state and local governments were privatizing many public utilities, and airlines and electricity largely moved into forms of market pricing. And as the judiciary moved in a more conservative direction with new conservative judges appointed, that encouraged agencies to be more timid for fear that even if they brought an antitrust action, the courts would largely block any significant intervention against any monopoly. So you now have new debates over what the role of antitrust law should be as this corporate concentration has begun to peak. There is one argument that says the point is to regulate monopolies, to keep whatever efficiencies of size. John Kenneth Galbraith was once one of the largest sort of liberal arguers for that position, versus others who encourage the proliferation of smaller firms and more competition. There is this issue of how does economic concentration not just potentially raise prices for consumers, but also undermine innovation. And in an era of the internet, how do companies leverage personal data, algorithms, and new internet technologies that operate platforms like Google or Facebook. And by having that data, be able to dominate the industries and new sectors where workers and consumers depend upon those new platforms. The worry is companies can use data and dominance in one set of businesses to gain advantage over competitors in other sectors. That data, by knowing exactly what consumers want and what they're willing to pay, allows companies to engage in price discrimination, where they offer different prices to different people based on how much they're willing to pay, creating often regressive wealth transfer. So what are some of the recommendations for antitrust reform? First, collect better data on market concentration. Have more focus on vertical mergers and how tie-ups at production in the chain from how you sell things to how it gets to the consumers lead to anti-competitive behavior. Revise merger guidelines to focus on a broader set of what are called citizen interest effects beyond the price, including effects on the availability of services, monopsony power that drives down wages for workers, and the effects on the financial system. Argues that the FTC should use its broader Section 5 power to fight unfair methods of competition that go beyond the Sherman and Clayton Acts, and require more business justification for mergers in concentrated markets, have a presumption against the merger, against clear public gains are provided. And especially with new platform powers on the internet, look at a public utility regulation model to provide the benefits people want while restraining any predatory behavior. And finally, requiring data platforms to open access to allow alternative services, goods, and software to freely interact with them. You'll go through the reading, and there's a large debate at this point that is pretty wide open on where antitrust law should go.